now 8 o'clock on Tuesday, the 6th of October, and our meeting is going to start. I do want to give you all a warm welcome, and I hope that you all had a very good and relaxing constituency period. Some of you I got to see last week when we were in Beaufort West, whilst we visited some of the schools, and that was really nice. I also, quite late last night, met a group of really inspiring social development colleagues who work at the Social Development Office in George, who have taken some of their personal time to donate to the department to come out to come and collect food parcels in Cape Town that's going to be distributed in the Eden Karoo area. And it was really interesting having conversations with them last night to connect what they do and what we do, and also sort of listening to some of their stories of how difficult a lot of our community members are finding COVID-19. It's quite heartbreaking to think that there's people waiting for food parcels, and this is the only meals that they are getting for months on end. So I also want to say thank you to all of the colleagues in the Department of Social Development who have been working sort of quite differently and under very difficult circumstances. So with that, members, I also want to remind everybody of the rules for online conferencing at the Western Cape Provincial Parliament, that all participants will be muted at all time. If you've not muted yourself, please do so now. If you'd like to raise a point of order, you're welcome to use the chat function. If you'd like to speak, you can identify yourself by just telling me who you are. In most cases, I think we'll know. And then you are, when you do speak, please use your microphone and your video. Members, if you find it difficult to have the video on with your internet connection, you're welcome to keep that off as well. And then if anybody uses the sort of tool to present, the request is that you keep your document on while you're talking, but when you're finished presenting, that you remove the document. I'm now going to ask members of the committee to please introduce themselves.
Good morning, Chairperson. My name is Ricardo Mackenzie.
Good morning, Chair. Wendy Philander.
Good morning to the meeting. It's Member Makamba Boyke.
Good morning, members Makamba Boycha, Van Vogel, Mackenzie, and Philander. Welcome. I'm also now going to ask that the colleagues from the department, as well as colleagues from the WCPP, also introduce themselves.
Good morning, everyone. The name is Lionel Arnold, Director Community Development. Just an apology from Mr. Ewu, who is taking a much-deserved break. I am joined by my colleague, Mr. Sols, but he will introduce himself. Thank you.
Good morning, Mr. Chair. Caesar Sols here, as Mr. Linus indicated, also with the Department of Social Development, Community Development Programs, Directorate, Social Relief Program. Thank you.
Good morning. I'm also Lionel van der Schuyf, Department of the Premier Legal Services.
Hello, good morning, everybody. Andre Leroux, Legal Advisor, Western Cape Provincial Parliament.
Good morning, everybody. Ben Daza, Senior Procedural Officer, Western Cape Provincial Parliament.
Is that everybody? Is Nomonde with us?
Yes, Chair. Morning, everybody. Nomonde, Procedural Officer for Standing Committee on Social Development.
Welcome, Nomonde. There's no need to hide.
Thank you, Chair.
Thank you very much, everybody, for introducing yourselves, and welcome to all of our guests and the colleagues joining us, both from the WCPP, the Department of the Premier, as well as the colleagues from Social Development. Nomonde, are there any apologies? Besides the apology from Mr. Heu?
No apologies, Chair.
So no apologies. And then do we know whether Member Baku Force is joining us?
I have no idea, Chair.
Okay. I see Member Van Vogel is here. Member Van Vogel, are you acting as an alternate to Member Baku Force? Member Van Vogel?
Chairperson, I am.
Perfect. No, thank you so much. That's good. Just good to note. Members, the purpose of our meeting today is the consideration and deliberation of the negotiating mandate of the Social Assistance Amendment Bill, Bill 8B of 2018. What I'm now going to do is I'm going to hand over to Advocate LaRue, the WCPP's legal advisor, and ask Advocate LaRue to give us the input on the submissions made. And members would have received a grid with the submissions from Nomonde. Advocate LaRue, I'll hand over to you.
Good morning, Chairperson. Thank you for that. Chairperson, I looked at the comments carefully. For my part, I do not have any legal concerns, constitutionality, or conflicts of laws or anything of that nature. I am, however, of course, prepared to answer questions to the best of my ability, should the members have any. So I don't have any issues that I would like to raise from my side, but I am here and I am listening, and I can answer questions as they come up. Thank you, Chair.
Thank you very much. And then I'm also going to ask Mr. van der Schuyf from the Department of the Premier, are there any comments that you'd like to make on the submissions on the bill, specifically sort of comments received from the public?
Thank you, Chair. I have nothing to add with regard to the comments that were received from the public in general. I just want to perhaps raise a point with regard to the appointment of the independent tribunal. We are of the opinion that there needs to be greater clarity with regard to the procedure, the process that needs to be undertaken before the tribunal is appointed. I understand that there was a late insertion to the, sorry, I'm just trying to find my documents here. There was a late insertion to the effect that the provincial, that the Parliament had to appoint the independent tribunal after consultation. I'm sorry, that the minister had to appoint the independent tribunal after consultation with Parliament. We feel that the process that needs to be undergone with regard to the appointment needs to be clarified. And then we've also had a suggestion that the provincial legislatures also be consulted with regard to the appointment of the independent tribunal. Once again, we feel that the process with regard to the appointment needs to be addressed. Thank you.
Thank you very much. So members, those are the 2 points. The comment that Mr. van der Schuyf was just making around the role of the provincial legislatures, it's something that came up in our last meeting as well, that the consultation should not just be with national parliament, but it should be after consultation with provincial parliaments as well. So that's something that we definitely looked at. Nomonde, can I ask you, are you able to put the submissions on the screen as we receive them? Namonde?
Hi, Chair. I'm in
Are
the
you
process
able-
of flagging them up.
Okay, sorry, I think my internet connection might be lagging.
Why? I don't know, I'm struggling, Chair, to log.
Okay, let me see if I can open it. Are you able to see my screen, Amonde?
Yes, Chair, I can see.
So the first comment is from the Children's Institute at the University of Cape Town, and that's sort of a general introductory comment on the bill, and it highlights the sort of precarious position that orphan children in the care of relatives are with regards to accessing the foster child grant. And then comment B is sort of just an expansion of the process that's been followed thus far in terms of going to the courts to make sure that extensions of the specific order that instructed the department to pay the foster child grant without interruption. And then it highlights the role of the provincial departments and using the children's court in order to reach eligible orphans to ensure that their court papers are extended in time. And it also just highlights there the pressure that's been put on the child protection system. And the first comment that they're making is that the Children's Institute welcomes the amendments in the Act. And the second comment there is where they note that the authority of the minister to make announcements on additional grants in certain categories will need the concurrence of the Minister of Finance, and then gives the minister the powers or the authority to prescribe additional regulations on the requirements for conditions that beneficiaries need to meet. So it just sort of welcomes that as well, and it gives advice in terms of sort of the pitfall. And then the comment 2 there is that the child support grant top-up is a first step towards the legal solution to the foster care crisis. And they are also saying that there's other available resources already, and this is only the start of the solution. So they're saying they're a comprehensive legal solution in this view has 3 components, and then they highlight those components, which is that it needs to be an adequate and easily accessible social grant.
Yes, we are supporting the bill because it's coming from the NCO.
Welcome, Member Baku Baku Force. So what they're saying there is that there needs to be amendments to
No, we are supporting. Remember, this provincial. Okay.
I'm just going to mute Member Baku Baku Force. So the three suggestions that they're making there is that the Social Assistance Act, which is currently tabled, Section 12A and Section 32, as well as the Children's Act, Section 1501, and that the amendment that they're welcoming in the Social Assistance Act is the enabling of the minister to introduce a new grant to the amendment, as well as to change the eligibility criteria for foster care in the Children's Act, so that orphaned and abandoned children living with relatives and they're placed there in foster care are able to access the higher foster care grant. And that's currently in the Children's Amendment Bill as well. So that comment is also just sort of general, not specific to this act. And then they're also saying that the next step would be support of welfare services. Although the Children's Act provides for a range of prevention and early intervention programs, should be available to all children who need them. And then they list what the programs are. And then they also list the access to the children's court to obtain guardianship. And then again, at the last paragraph, they currently list the process that as it is at the moment, which is sort of quite a haphazard process because it means that guardians and relatives need to approach the court. In their third comment, they talk about the passing of the amendments and how that relates to the child support grant top-up. This is sort of expanding on the authority of the executive to decide which children are eligible for the top-up, how many children will be eligible, what documents are required, and what the amount of the top-up of the child support grant is. And then they give some suggestions on what that amount should be in terms of hard numbers. And then also, this is again giving advice in the next point around including single orphans, because currently the foster care grant is currently available to children who are orphaned and abandoned. And then also indicating that the administrative process for application should be quick and easy for families to access. And then in the next column, they talk about orphaned and abandoned children in the care of relatives who are already getting the foster care grant. And then they're saying that they should remain on that foster care grant until they age out, which is at either 18, 19, 20, or 21, depending on the circumstances. And then they're saying that there'll need to be a transitional clause in the Children's Act to facilitate that. So in summary, they support the child support grant top-up as an essential part of the comprehensive legal solution. However, they caution that the emphasis will need to be on the inclusion of all eligible children, as well as those in the difficult category, so people who are orphaned by one parent or abandoned by another. So they're saying that the department needs to look specifically at that. They talk about the value of the child support grant, and then the changes to the Social Assistance Act needs to be supported with parallel amendments to the Children's Act to clarify those kids in those sort of complicated categories. And then all of the amendments and accompanying regulations need to be clearly communicated to all officials and other role players. The next submission is from the Commissioner for Children in the Western Cape. And the Commissioner broadly supports the amendments in the Social Assistance Amendment Bill, specifically relating to the child support grant. And she gives reasons for why. The Commissioner also notes that children have the right to be involved in all decisions affecting their lives. She's saying that children have not been adequately included in the lawmaking process. And she gives an example there of how she thinks children should be included, and this is something that we can take forward as a committee. in terms of how we include children in participation. It's something that we've struggled with as well. So the Commissioner for Children in the Western Cape supports, and then we've got the Western Cape Provincial Department of Social Development, specifically making reference to clause 5, where they're saying consideration should be given to removing the means test for social relief of distress for victims of disasters. Residents who live in fixed permanent structures should be granted access to social relief of distress in the event of disasters. And the motivation there is that victims who live in fixed permanent structures do not currently qualify for social relief of distress. Then comment on clause 7 is that a retired social worker who is registered with a professional body and a legally qualified person should form part of the independent tribunal. Furthermore, social workers who are registered with a professional body should be permitted to make representations to the independent tribunal on behalf of applicants. And this speaks to the point that Mr. Van der Schuyf was making around defining the process of appointing the tribunal. And the motivation there is that the independent tribunal must apply Batopile principles in its functioning. Having a retired social worker and legally qualified person sitting on the independent tribunal will enable them to provide the expertise and objectivity to the proceedings. Having a social worker who is familiar with the amendments, with the requirements for lodging appeals, to assist applicants to lodge appeals with the independent tribunal will hasten the proceedings, so it will make things easier. And then this is a proposal to clause 7. So this is an amendment to propose section 18(1), which will read that the minister must, after consultation with Parliament, appoint an independent tribunal. It is submitted that clarity is required with the appointment process. Furthermore, it is submitted that the minister must, in addition to consulting with the National Parliament, also consult with the Provincial Legislatures before appointing the independent tribunal. And the motivation there is that section 18 provides for an amended appeal provision. It is submitted that clarity is required regarding the proposed subsection 1 regarding that appointment of the independent tribunal. So how do you define what an appropriately qualified person is? And also what is not provided in the process by which the independent tribunal is appointed is the provision merely states that the tribunal must be appointed after consultation with Parliament. So what processes must be followed? Must the minister advertise for nominations from the public? Can the public object to nominations? What are the timeframes? What role does Parliament play? That's not clearly defined. Must the list of persons be submitted to Parliament? Can Parliament veto the nominations? The provision states that the minister must appoint the tribunal after consultation with Parliament. This is not the same as in consultation with Parliament. The phrase after consultation with requires that the ultimate decision must be taken in good faith after consulting and giving serious consideration to the view of the other functionary. This contrasts with in consultation with another functionary where there must be concurrence between the ministers. And then there's some legal precedent that's cited there. And it says there, it is the intention that the minister must consult Parliament, but not be bound by Parliament's decision regarding the appointment of the tribunal. So that's something that we need to think about, members. So it is submitted that clarity is required in that regard. Consulting with the provincial legislatures will afford these legislatures the opportunity to formally assess and provide comments on the proposed nominations for the independent tribunal in the best interest of the provinces. And then a comment to clause 10C is that the word should read the minister with concurrence of the Minister of Finance may determine additional payments linked to a social grant by notice in the Gazette. And the motivation is that it is submitted that the by notice in the Gazette contemplated in proposed section 32(3) applies to both paragraphs A and B and should therefore be placed in a separate line. And then just general comments, the Provincial Department of Social Development welcomes the Social Assistance Amendment Bill, as they believe that the realization of socioeconomic rights is critical to South Africa overcoming the persistent challenges of poverty and inequality. The department welcomes the bill in the context that it places tremendous strain on the current foster care system and the need for much needed social worker services to be directed to prevention and early detection work. And they go on to give a motivation of sort of why they think it's important, and also go into the background. And then the next comment was received from the West Coast District Municipality, who also joined us at the public hearing. They welcomed the amendments, and they also indicated that the amendments will fast track the adjudication process. And they propose that these amendments be streamlined with interventions to combat other social ills that negatively impact the welfare of children. And they say that the West Coast District Municipality remains committed to create a safe and secure environment for the holistic development of our children as far as possible within the functional mandate and competency of the municipality. The next comment is from the Commission for Gender Equality, and the introduction outlines what the CGE does. Then they give the contextual background, which centers the approach in a sort of a gendered approach. Then they say in Section 1 of the Act, the definition clause of the bill, the insertion of disaster and independent tribunal. So the Commission observes that the inclusion of the definition disaster in Section 1 of the Act, this is a fundamental in view of the COVID-19 pandemic in South Africa that resulted in most South Africans losing their jobs. The pandemic further left women destitute due to a lack of income. The inclusion of the disasters under the Social Assistance Bill will go a long way in addressing poverty in women-headed households. And they're saying that this provision should primarily consider the vulnerability of women. They welcome the inclusion of the independent tribunal and hope that the independent tribunal effectively addresses the appeals, and that they're saying that the members of the tribunal must have the necessary expertise, and this must include the expertise of gender-related issues in South Africa. They're saying to strengthen the powers, the tribunal decision should be binding to the department unless such decisions are considered irrational, unjustifiable, and does not pass the test of fairness. And then the next comment is on substitution of Section 6 in the Act. And then they're saying the Commission observes that the death rate due to various factors in South Africa often results in children being orphaned and consequently requires a primary caregiver. There are reports of abuse of child support grants by caregivers. From this premise, the Commission welcomes the inclusion of a child who heads a child-headed household as contemplated in Section 137 of the Children's Act. So the Commission for Gender Equality generally welcomes the proposed amendments, and then they've made some suggestions on how those regulations for the operation of the tribunal could work. Nomonde, I'm just checking with you. Is it okay if we go clause by clause based on this document, or do you need us to go clause by clause into the bill?
It's supposed to be clause by clause of the bill, Chair. You table the bill clause by clause so that members can also make their input if there's any, but that can be also be done in line with the document that you just opened.
Okay. Members, can I ask, are there any questions before we move on about the document that was just tabled? Are there any questions of clarity that you have to both the legal advisors from the Provincial Parliament as well as the department?
Chairperson, can I go?
Yes, you may, Member Mackenzie.
Thank you for that document. We've been through that document. The changes that we suggested, which one or two of them I see also found its way into the comment section by, I think, UCT, something that we discussed at our last meeting. Will we see where our proposed changes, where the in consultation, after consultation, because that's something that I know as a committee we raise as a concern. I know what some of the members of the committee asked, for example, where is this post going to be advertised? Is it going to be Parliament? Is it going to be the executive, etc.? Are we going to, has that been incorporated into the draft bill? Will I see it there? Because I'm trying to find it in the draft. You can just give me some guidance, please. But I see it in the comment section because those are similar to what we made. So let me leave the comment document and go to the bill perhaps. Perhaps if we go by the draft bill as you'll guide us, then I'll find it there. Thank you.
So it's currently not in the text of the draft bill. And if we make any amendments, we have to include it in today's meeting.
Okay. Or will that be, or can I perhaps ask is this way, will that be our mandate we give to our delegate with our proposed amendment? Sorry, I think I phrased it differently earlier on. Will our proposed amendment to our delegate be with our suggested amendments?
Yes. Okay. Members, are there any other questions of clarity? So sort of we all covered, we don't have any other questions. If you do, please just sort of alert me and then we can have those answered. So members, I'm now going to table the social assistance amendment, the social assistance bill for discussion. And just for ease of reference, it's going to be easier for me if we go according to the table. So if I go back to the top, so the comments from the Children's Institute for me was largely sort of supportive, and there were suggestions in terms of how further changes in the other parts of the complementary legislation needs to be made as well. There's a very strong motivation there also to define the regulations. So if we go to the comments by the department, so if we go to clause 5 of the bill, so the comment there was that the consideration should be given to removing the means test for social relief of distress, so that residents who live in a fixed permanent structure should be granted access to social relief of distress.
Chairperson, my deepest apologies. I can't put my hand up for some reason.
Oh no, that's fine.
Are we going to the bill first, or are we going to the comment section first?
So from the way I'm reading it, it's easier to read the sheet with the comments on it and then just find that section in the bill. But members can guide me. Would you like us to go the bill clause by clause, and I can ask Monday to put the bill on and we can go through it like that?
I think perhaps go as you intended. I think if you go to do it the way you wanted, it is much better actually.
So then if we're currently looking at section 5, it's a section that deals with relief of distress. And the comment that we received there is that consideration should be given to removing the means test. So at the moment, it says there that the social relief of distress, one, a person is subject to section 5, eligible for social relief of distress if the person qualifies as prescribed. notwithstanding subsection 1 and sections 27, 41, and 55 of the Disaster Management Act, any person may qualify for social relief of distress if his or her household has been affected by a disaster. The agency must, subject to subsections 1 and 2, disburse the social relief of distress as prescribed. Notwithstanding subsection 2, the agency may, in any event of a disaster and depending on the magnitude of the disaster and the availability of resources, determine as prescribed the needs of the affected communities and disperse social relief of distress. So the Western Cape Provincial Department of Social Development is asking us there to remove the means test. Can I just ask Mr. Arnolds, are you able to just give us some clarity in terms of the means test at the moment and what is it that you want us to remove?
Thank you very much, Chairperson. I'm going to ask Mr. Sauls to just deal with this point, just to give some background and clarity, and maybe also to say that while the amendment bill do not specifically specify the means test or the eligibility criteria, it does impact on the policy for SRD. But I'll allow Mr. Sauls just to give just a background to explain. Mr. Sauls.
Good morning, Mr. Chair and all connected participants. Just a brief context. The role of the Provincial Department of Social Development is to facilitate access to the social relief benefits to victims of disasters, whereas the administration of the social relief benefits resides with the South African Social Security Agency, SASSA. Hence, the focus is with regards to the implementation of the social relief to victims of disasters. Now, the social relief disaster response to victims of disasters by the South African Social Security Agency is currently two-pronged, namely immediate temporary relief, which pertains the provision of food either through hot meals or food parcels, and non-food material assistance, which is blankets, mattresses, male and female dignity packs, as well as baby packs. And then the second response is a once-off cash amount, which is equivalent to an adult grant amount. Now, the mentioned disaster mitigation responses is very admirable. It, however, lends to be compromised because of one, the conditions attached to receipt of the benefits. Now, for the immediate temporary relief, it is not available to victims of disasters if they are not accommodated in a war. Secondly, it is not available to victims of disasters residing in formal houses regardless of their state of poverty. The once-off cash amount, it is means tested, which implies that victims of disasters must qualify for the benefit. So the department petitions that the social relief benefit should be awarded indiscriminately to all victims of disasters, given the deepened social vulnerability experienced by victims of disasters. Thank you, Mr. Chair.
Thank you very much. So just in terms of the wording and how we change this, so am I right in assuming that what you're asking us to do is to change the wording to say that victims of disasters, irrespective of where they live, should be granted relief of distress, specifically victims who are in permanent structures, and there should be no consideration of victims moving to a hall. I'm just trying to get the wording right.
Yes, Mr. Chair, that would be correct, yes. There should be no distinction in terms of where people, in the type of structure that people stay, because people are affected by disasters, whether they stay in formal houses, sub-economic houses, or in informal structures. and the issue of being accommodated in walls should not be a factor for people to receive or not receive benefits, because on the ground that we have tested it, and people have indicated to us the reason why they do not want to go to walls is that they would rather sit on site where their structures were burnt or damaged, because they fear that if they move to walls, that the plot will be taken by someone else. Thank you.
Thank you. So just, I just need to be guided here by our legal eagles. Are we able to just insert a 0.5 there, or do we have to edit, sort of amend one of those 4 points there already? Mr. LaRue?
Chair, I have a question for the department, because I have some difficulty relating. I understand the concern of the department from sort of a policy perspective, but I'm trying to relate it to the text of the bill. And I'm also wondering, and this is a question, in clause 5, it refers to section 13, and I'm reading there section 13.2. So that's the proposed section 13, subsection 2. Now I read there, it says, notwithstanding subsection 1 and certain sections of the Disaster Management Act, any person may qualify for social relief of distress if his or her household has been affected by a disaster. My question is, does that not address the department's concern? Because it seems to me to open the scope of people that qualify for social relief of distress quite significantly. It says any person will qualify. Yes, maybe the department can just help me with that.
Thank you. And then I saw Mr. van der Schuyf as well.
Thank you very much. I just want to raise a point here with regard to physically making amendments to the bill. We need to be very careful with what we do for a number of reasons. Firstly, we weren't privy to the policy decisions that took place behind the drafting of the bill. Secondly, the bill uses a certain style that we need to follow and adhere to. And whatever insertions or amendments we make, we need to take into account not only the bill, but also the whole of the act. It's not just simply a case of inserting a few words here and there. We need to assess the consequences of those insertions in light of the whole act. I just want to raise those points as general considerations with regard to drafting.
Thank you.
Thank you.
Mr. McKenzie, I see your hand, and then Makamba Boyka.
Yes, Chair, my hand was up earlier on, and I think the last speaker covered me. What we, and further to the comment by the previous speaker, because I think the concern, one is the concern from the department, obviously that individuals who live in fixed permanent structures do not currently qualify based on their motivation. But then second of all, obviously if, my second point on this matter would be, if there is anything that needs to be changed on this, can that not come out in the regulations when individuals apply for social relief? And the third point is, we don't have to necessarily change it here. We can submit it as part of our motivation to the NCP, as the last person said, because I don't know if there was discussions around costs, for example. If I, Ricardo, can afford, let's call it a permanent structure, is that not a baseline already for them to say, let's exclude Ricardo from social relief, because by definition, he can afford some sort of permanent structure. Does he not qualify? And I understand the department's concern, but I don't know what the drafters were thinking when they did this. And perhaps we can put it in our notes to the NCP for them to have a look at, because like I said, I don't know what the drafters of the legislation were thinking. Did they have that into account, that the fact that Ricardo's already can afford some structure that means he should not qualify. I don't know at this point what they were thinking. Thank you.
Member Makamba Boycha.
Thank you, Chairperson. My question might not be related specifically on that. It's somehow, I just know if the Act does provide us with a list or the type of disaster that the Act is referring to, or does the Act have a specific definition of what a disaster is? My question is actually emanating from an incident in the Eastern Cape of 4 members from the same family who were killed, who were shot and killed. And there was no role that was played by the Eastern Cape government. So I just want specifically in that type of an example, what is the role of social development in those cases? And is there a specific definition or how does it work? Thank you, Chair.
Okay, and then I see Mr. Arnolds.
Yes, thank you very much, Chairperson, and thank you also to the colleagues for the questions of clarification. Chair, just to maybe also move on this point, the intention here in inserting this is not to change any of the or insert anything in the clauses, as this is purely a policy matter, because the reference to eligibility finds itself within the policy for social relief, and hence the proposal would be just to note this, but not to insert it as obviously eligibility based on experience, that this obviously translate into the policy. So for now, Chairperson, the request is that no insertions be made, but that also on a policy level, in terms of the SRD policy of SASSA, that this matter be dealt with.
Thank you. Member Baku Force.
Thank you, Chair. No, I wanted to comment on the change of some of the clause. Chair, I think the bill is not our draft. So I thought we are going to write the recommendation, or the organization can just forward their recommendations, and then we submit it in the NCOP. Yeah, that's my take. I'm not sure if I'm in the right path, but that's how I think. Thank you, Chair.
What we have to do today, members, we'll go clause by clause on the bill, and if there are any amendments that we want to make, we need to note that now, and that goes through the NCOP, and that forms part of our negotiating mandate. So what we're going to do now is we're going to go through clause by clause, and if there are any amendments that we'd like to make, we'll put that in, and then we'll also submit the matrix to the NCOP. So a lot of the comments are sort of supportive of specific aspects of the bill, and we can send that through as public comments. And then there's some things, if there's things that we feel strongly that we want to change, those are the things that we can then discuss now. I still see Member Mackenzie, and then I see Member Baku Force, your hand is still up. Is that a new hand or? Member Mackenzie and Member Baku Force, is your hand up?
I lowered my hand, sorry.
Okay. I'm assuming Member Baku Force's hand was from earlier. Okay, members, so what I'm going to do now is I'm going to ask you to just be vigilant and think about the matrix that you have, and think about which of those comments on the matrix you feel strongly about that we should, if you do want to add it in as an amendment. But I'm now going to then table the bill as is sort of per section. And I'm just looking, the copy that I've got printed out here doesn't have numbers on it, but the PDF should have numbers on it. So we're now on page 2, which is that it's the amendment of Section 1 of Act 13 of 2004, as amended by Section 99 of Act 75 of 2008. So there they are inserting the definitions of a disabled person. Also, after the definition of disabled person, they're inserting the definition of disaster, meaning that it's a person defined as a disaster in Section 1 of the Disaster Management Act. And I think, Member Makamba Pocha, I'm going to still just table your question for Mr. Arnold's and Mr. Sauls to think about, but this is when they talk about disaster, they mean as defined in the Disaster Management Act. And then the point B is of inserting the definition of the independent tribunal, which means that the independent tribunal appointed by the minister as contemplated in Section 18. And then by the insertion after the definition of parent of the following definition: a person for the purpose of social relief of distress in the event of disaster means the head of the household or anyone within the household acting on his or her behalf, or an organization rendering disaster relief services. And then D, by the substitution of the definition of social assistance of the following definition: social assistance means a social grant, social relief of distress, or an additional payment contemplated in Section 12A. And then if we go to page 3, it says amendment of Section 4 of the Act. Section 4 of the Principal Act is hereby amended by the substitution of the heading of the following heading: provision of social grants, assistance. So the word assistance is added there, by deleting the word and at the end of the paragraph F, and the substitution of the expression and for the full stop at the end of paragraph G, and the addition of the following paragraph: social relief of distress. And then the next one is the substitution of Section 6. The following section is hereby substituted for Section 6 of the Principal Act: child support grant. Subject to Section 5, a person who is the primary caregiver of a child, or a child who heads a child-headed household, as contemplated in Section 137 of the Children's Act of 2005, Act number 38 of 2005, is eligible for a child support grant. And then the insertion of Section 12A in Act 13 of 2004. The following section is hereby inserted in the Principal Act after Section 12. Additional payments. The Minister, with the concurrence of the Minister of Finance, may prescribe an additional payment linked to a social grant. The Minister may, in prescribing an additional payment, differentiate on the basis of need between beneficiaries of social grants. Substitution of Section 13 of Act 13 of 2004. The following section is hereby substituted for Section 13 of the Principal Act: social relief of distress. 1. A person is subject to Section 5, eligible for social relief of distress if the person qualifies as prescribed, notwithstanding subsection 1 and sections 27, 41, and 55 of the Disaster Management Act. Any person may qualify for social relief of distress if his or her household has been affected by a disaster. The agency must, subject to subsections 1 and 2, disperse the social relief of distress as prescribed. Notwithstanding subsection 2, the agency may, in the event of a disaster and depending on the magnitude of the disaster and the availability of resources, determine as prescribed the needs of the affected communities and disperse the social relief of distress. And members, I'm just going to remind you that if there's anything at any point you'd like to change anything or you'd like to stop me, please do so. So Nomonde, I'm at the bottom of page 3 now. The amendment of section 14 of Act 13 of 2004, as amended by section 2 of the Act of Act 5 of 2010. Section 14 of the Principal Act is hereby amended by the substitution in subsection 3B for paragraph 3 of the following subparagraph. So that paragraph 3 is of his or her right to request consideration, to request reconsideration and his or her rights of appeal contemplated in section 18 and of the mechanisms and procedure to invoke any such right. And then substitution of section 18 of Act 13 of 2004. The following section is substituted for section 18 of the Principal Act. Appeal against a decision of the agency. So it says 18(1) there. The minister must, after consultation with Parliament, appoint an independent tribunal comprised of appropriately qualified persons as may be prescribed to serve as members of the independent tribunal to consider the appeals against the decisions of the agency contemplated in subsection 2 in the prescribed manner. So members, my proposal is that we amend that section to read that the minister must, after consultation with Parliament and the provincial legislatures, appoint an independent tribunal. Members, are you still here?
Yes, Chairperson, I can go with you. Chairperson, can I just make something? We discussed some of the changes in the last meeting. I'm just incorporating some of them in here now, because that's probably much easier.
But that's what we're doing now. So we now need to put those changes into.
Okay, I'm happy. I'll follow your lead. Thank you.
Did I see another hand as well?
No, I support the changes, Chairperson.
So then the question, members, so the word that I'm inserting is that the minister must, after consultation with Parliament and provincial legislatures, appoint an independent tribunal. But then one of the questions on the matrix that where clarity is asked is, do we want to use the word after consultation, or do we want to use the words in consultation, because they've got very different meanings? Members, I'm going to take guidance from you here. Member Makamba Bocha.
Chair, I think the best wording would be in consultation, because after consultation, there's going to be a lot of discussions that needs to take place. Whereas in consultation, we are actually in the same position of making any decision that permits us to do so.
Thank you. Member Bako Force, I see your hand. Member Bako Force, can you hear me? Member Bako, have you disappeared? Okay. Nomonde, can we just ask IT just to check what happened to Member Bako Force? Her hand was up and then she disappeared. Mr. LaRue, I see your hand.
Thank you, Chairperson. Sometimes it's difficult to comment without being behind the thinking of the sponsoring department that drafted the bill. I think there's an argument to be made that after consultation with Parliament is preferable, because I agree, if one says in consultation, then one makes Parliament a co-decision maker in a manner of speaking. So the decision to appoint the tribunal or who to appoint Parliament becomes the decision maker. I don't know whether it was the intention of the department for Parliament not to become a decision maker, so that Parliament can maintain oversight of the minister and of the work of the independent tribunal, which of course it's could be complicated if the Parliament itself was actually a co-decision maker in appointing the tribunal. I'm just raising that. As I say, I don't know what the department's intention was or what the thinking was, but maybe there's good reason why the word after consultation is used rather than in consultation, because that ensures that the minister ultimately makes a decision, and then the minister must account to Parliament for that decision. Chair, if I can also just one other concern, when if I read the expression after consultation with Parliament, I mean, we work in a legislature. I have difficulty understanding how that would practically work. With who in Parliament and with who in the provincial legislature, because it seems to me that the legislatures in Parliament will I don't know, will maybe now have to craft a special procedure to deal with this. Wouldn't it be preferable to stipulate what body in Parliament should be consulted? Thank you, Chair.
Thank you. Member Baku Force, you're back. Member Baku Force, do you have a comment? Your hand was up earlier before you disappeared. Okay, so members, Advocate LaRue just raised sort of a few points there. The one being that we're not sure what the intention.
Hello.
Yes,
okay.
member.
Can you read sometimes the subject? No.
Member Baku Force, we can't hear you. Okay, I think we've lost Member Baku Force there again. So, members, Advocate LaRue just raised a few points there. The one being that we're not sure what the intention of the drafters were when they used the words after consultation, and if we alter the wording to in consultation, it significantly alters the role of the minister in decision making and the role of Parliament. And then the question there also is whether we want to be clear and say, if we're saying after consultation with Parliament and provincial legislatures, do we then say that it goes to a specific committee, or do we leave that open so that the Speaker and the programming authority then decides, or the Speaker then enables provincial legislatures to make up a process of how you deal with it? Can I get input from the members?
Chairperson?
Yes, Member McKenzie, and then Member Makamba Bocha.
There is a set procedure for when ministers appoint boards or tribunal, even national parliament. I mean, there's a set procedure. They advertise it. They recommend candidates. I mean, we've got legislation in the Western Cape where we appoint, for example, the liquor board, where we all were party to appoint. So there are set procedures. I'm not sure I understand the legal advisor's question properly, unless I misunderstand something. Because if parliaments appoint the SABC, for example, they put notes out and they recommend a list to the minister, and the minister appoint. And I think that's why when we looked at the legislation at the previous meeting, we said, what was the intention? Was the intention for the minister to appoint this individual, or was the intention for the minister to get Parliament to advertise the positions and then Parliament appoints these individuals or give the minister a short list and the minister take from that short list. So I'm not sure if I'm misunderstanding Mr. Advocate Leroux on his question. Is he asking those procedures that the minister needs to follow? I'm not sure I get the question, because then I can assist on that. Thanks.
Okay, Member Makamba Bocha.
Thank you, Chairperson. I was under impression that now that we have a legal expert in the meeting, they will probably give us guidance in terms of the meaning of words, in terms of legal terminology, as what do they mean, so that we can get guidance on this particular matter. Thank you, Chairperson.
Thank you. Advocate Leroux, do you want to respond to Mr. Mackenzie?
Chair, on that issue, I've picked up in the comments that the expression here, after consultation with Parliament, was added a bit hastily. And it seems to me that way. I think the point I'm trying to make is, if a law imposes an obligation of consultation with Parliament, we need to remember that Parliament consists of the National Assembly and it consists of the National Council of Provinces. What exactly is being required here? How will this requirement be satisfied? Will it require a resolution of the National Assembly and the National Council of Provinces? The use of the word Parliament is very vague. I agree with Mr. Mackenzie, for example. Member Mackenzie refers to our own processes for appointments to the Liquor Board and appointments to the Racing and Gambling Board. That's correct. I note there that those regulations, because the process there is provided for in regulations, I think in the case of the Racing and Gambling Board, but there's a specific reference to a particular committee. So we know exactly that we need to approach a particular committee to make a recommendation or to make a decision. Thank you, Chair.
Thank you. Member Mackenzie, is that a new hand?
Yes, thank you, Chair. Then perhaps if I get Mr. Leroux's point now, Advocate Leroux's point. So would he be comfortable if we then change it after consultation with the appropriate standing committee in Parliament? Would that be satisfactory?
Chair, yes, that would words to the effect with the relevant portfolio committee, or whichever committee is responsible to have oversight of the administration of this act. Yes, that would make sense to me.
Okay.
So members, then that line will read: the minister must, after consultation with the relevant portfolio committee in Parliament and the relevant standing committee in the provincial legislature, appoint an independent tribunal.
That's fine.
The rest of the members, are you still with us?
Yes, Chairperson, agree.
Thank you very much. And Amanda, you've got that noted?
Yes, Chair.
Okay, and I fear that my reading word by word is making you all fall asleep. So I'm now just going to table the whole of section 7. So I've tabled that, and we've now amended the first part in terms of saying there that the minister must, after consultation with the relevant portfolio committee in Parliament and the relevant standing committee in the provincial legislatures, appoint an independent tribunal. And now I'm going to section 8. Are there any changes that members would like us to consider in section 8? And that section deals with changing the structure of the independent inspectorate. Instead of it being a separate national department, it is contemplated that it must be part of the Department of Social Development. I'm now tabling section 9. Are there any changes? Member Mackenzie, I'm just going to lower your hand because it's still up. Now tabling section 10.
Chairperson?
Yes, Member Mackenzie.
I just wanted to confer that under section 7, under clause 7, that one of the recommendations was that are we going to try and push that into the regulations, that in terms of the retired social worker who's obviously registered with a professional body and legally qualified should make part of the independent tribunal? Are we going to try and get sort of who should be on the tribunal as part of our regulations? Just give guidance on that, please.
We don't have the regulations in front of us at the moment.
Okay, no, what I'm suggesting is when we submit our comments to the NCOP, and some of the comments we received from our social partners in the Western Cape, including obviously UCT, the Western Cape Social Development, that these things should be included as part of our negotiation mandate in our recommendation.
I think we should submit the comments that we received. Yes, I think it's worth doing that, because when the department then drafts the regulations, those are things that they can rely on when formulating those regulations.
But sorry to interrupt you, Chair. The reason I'm asking it, because what tends to happen, and this is just my opinion, obviously, is that when the NCOP receives all these comments from all the social partners, and there are 9 provinces and there are thousands of comments, it tends to become part of the comments section. If they receive from the standing committee as part of our negotiating mandate a recommendation, obviously the comments will be an addendum to our recommendation, but clear recommendation is what the standing committee has recommended, and one of the recommendations is that the regulations should ideally include on the tribunal. It can be in minutes of our meetings. It's just been an addendum to our minutes. I hope I make sense. There's just a few key things that we want out of this committee.
I'm going to ask Nomonde and Ben if they could guide us. What would be the best format to submit the comments in, to make sure that they're actually looked at? Nomonde or Ben? Or before you go, I see Member Baku Force.
But Chair, keep on lowering my hand because my hand was up.
You keep on disappearing. I've been trying to get you for a while now. You can go ahead, Member Baku Force.
Nature, again, I wanted to say, as I said before, you know, this is not the first time Parliament has worked on appointments. I think we should support the bill as it is.
Member Baku Force, are you able to just move around? We can't seem to hear everything that you're saying. It's coming through sort of broken.
To keep it as it is and not include the proposed change to include the Chair.
Yes, Member.
Can you hear me?
I can hear you, yes. Can I just ask if I heard correctly what you said? You're saying that the committee shouldn't make any changes? Member Baku Force?
What I was in that, Chair.
So I didn't get the last part. Can you repeat that, please?
Oh, sanction.
Member Baku first, just for clarity, so I make sure that I heard correct. Are you able to tell me, are you saying that you're suggesting
The process is followed will set all requirements to us, keep it as it is, and not include proposed change to include standing. This is the first time the Parliament has been. I don't know if we to keep. Can we support the bill as it is? Not sorry, that's what I'm asking, Chair.
Okay, member. So member Baku Force is asking that we support the bill as is and we make no changes. I don't support that view because I think that would be irresponsible, because we've clearly been given a mandate to canvass the opinion of the people of the Western Cape, and we need to feed their opinion through. Are there any other views?
Chairperson?
Yes, Mr. Mackenzie?
We are in the process of making changes to this bill, so we're clearly not accepting the bill as is.
Okay.
Chairperson, I agree.
Okay,
We have to amend.
Member Baku Force?
Chair?
Yes, ma'am.
No, I didn't say anything. I'm done.
Oh, okay. Now your hand is still up.
Oh, okay. But Chair, you keep on disappearing. I don't know even if you heard what I was saying. I hope it's noted that I'm proposing that we submit we support the bill without amendments or any changes.
Okay, now we've heard your comment, and then we also disagreed with your comment because we've been mandated to make those changes and we're doing them now. So we're putting our changes forward for our negotiating mandate. Members, if I can go back to Nomonde just to guide us on what would be the best way to submit the comments to the NCOP.
Hi, members. Comments to the NCOP on this piece of legislation will form part of the committee negotiating mandate. We are not going to submit a different document. There will be one document from the Western Cape Provincial Parliament with suggested amendments and comments, if that is what members are suggesting. So they form part of the negotiating mandate of the Western Cape Provincial Parliament. You make amendments on the clause, we will note those amendments in the negotiating mandate, then we'll have also part of the comments where you have to elaborate. But I will work closely with the chairperson. We've been doing this for quite some time. It forms part of the suggestions. I don't know whether I have answered correctly. Maybe I didn't even understand the question.
I understood you, so that's fine. I'm sure other members did as well. If they didn't, they're welcome to just raise their hands and let us know. So members, just to go back, we were on section 7 and we agreed that we're proposing that the changing of line 18, one should read, the minister must, after consultation with the relevant portfolio committee in Parliament and with the relevant standing committee at the provincial legislatures, appoint an independent tribunal comprised of appropriately qualified persons as may be prescribed to serve as members of the independent tribunal to consider appeals against decisions of the agency contemplated in subsection 2 in the prescribed manner. And then we will attach the comments that were made in terms of the competency of the tribunal members and who we think should be on that tribunal as comments. I'm now moving to section 8, which we've covered as well. And then section 9. And then now dealing with section 10. And then section 11, which deals with transitional agreements. And then section 12, which is just a short title and commencement of the bill. And then the attached, Namonde, are we going through the memorandum as well, or we can leave that as is?
You can leave it as is, Chair.
Okay. So, members, I've now tabled that. I see Mr. LaRue.
Chair, thank you. I'm just observing on clause 10, which amends section 32 of the Principal Act, that the provincial department made a recommendation concerning how 10C should be drafted, by which they say that the words by a notice in the Gazette should be, I use the term a sandwich clause, but it should be drafted, it should be notched out, so that the requirement by notice in the Gazette applies to both paragraphs A and B above. I think that is a good proposal by the department, if the committee wants to consider that. Chair, also, I'm just looking at the paragraphing here in clause 10, and maybe we can recommend to the department that they just okay, no, never mind that comment. Thank you, Chair.
Thank you, member. So there is, that's looking at, when you look at the matrix on page 11, it's amending 10C. So the wording should read the minister with the concurrence of the Minister of Finance. And then it says A, B, and then B is may determine additional payments linked to a social grant. And then it's asking us to put by notice in the Gazette in there. Members, are you happy to support that?
Yebo.
Yes, Chairperson.
Okay, so Namonde, will you just take note of that and then just make that amendment as well? Members, are there any other points that you'd like us to consider before I table? Member Makamba Pocha?
Thank you, Chairperson. I do support the Children's Amendment Bill. However, it actually been better if it had gone as further in making administration requirements burden to children who have do not actually know who their fathers are. They've been abandoned by their fathers since birth, and it makes it difficult to locate the fathers or to obtain details of as required. So, secondly, the bill makes provision for establishment of inspectorate component. However, it does not deal or assist in the reduction of the backlog within the foster care services. Thank you, Chair.
Thank you, member. There are amendments to the Foster Care Act that's also coming our way fairly soon. And maybe that's something we need to look out for when we've got that piece of legislation, as well as when the amendments to the Children's Act comes through. So we must just bear that in mind when that comes through. Members, so I'm now submitting So just in terms of the mandating procedures of Provinces Act 52 of 2018, I require that that requires the committee indicate whether it votes in favor, against, or abstains from voting in the bill and the amendments, if any. So I'm now going to just read what our report would say. So it would say that the Standing Committee on Social Development, having considered the subject of the Social Assistance Amendment Bill, Bill 8B 2018 NCOP, refer to it in terms of the Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill with the proposed amendments. Members, are you happy with that?
Yes, Chairperson.
Yes, Chair.
Concur, Chair.
I see your hand is up.
Concur, Chairperson. Thank you.
Thank you, Member Baku Force. Member Baku Force, am I seeing your hand?
I'm saying, Chair, I'm still maintaining my word. I'm supporting the bill without amendments.
Okay, so we have support from Member Mackenzie, Member Philander, and Member Makamba Pocha, as well as myself. That constitutes a majority, so the committee will then support. Just before I close, I just wanted to go back to the question that Member Makamba Pocha asked, and I wanted to ask Mr. Arnolds or Mr. Sauls if they're able to respond to that. It was a general question around the role of the Department of Social Development when families face incidents of violence, which is not necessarily prescribed as a disaster in the sense of how the Disaster Management Act would define it, but what support would be available broadly to those families. Member Makamba Pocha, did I capture that correctly?
Yes, Chairperson, it's correctly captured.
Thank you. So I'm just going to hand over before we close to Mr. Sauls or Mr. Arnolds if they want to perhaps proffer an answer, or they can come back to us with an answer in writing as well.
Yes, Chair, I'm going to allow Mr. Sauls to just respond. Thank you.
Thank you, Mr. Chair. Yes, you are correct, Mr. Chair. The application for death benefits is captured in the social relief policy, but it is, of course, it has to come on the back of a declared disaster. Now, with regards to non-declared disaster deaths, if I may put it like that, there is in the province, we have the burial assistance program, for instance, and I'm not saying this is uniform. That includes the response of various departments, like the Department of Health, as indicated SASSA, the municipality. Example, the City of Cape Town has the Mayoral Special Fund that focus on children that died under specific circumstances, and of course the City of Cape Town, the burial and cremation policy, etc. Now, the Department of Social Development in the province, as a last resort through the discretion of the Minister of Social Development. So in a nutshell, that is the response within the province. Not necessarily, you cannot necessarily speak for what is happening in other provinces. Thank you.
Okay. Member Makamba Pocha, can I propose that we put this as something that we'd like to explore a bit further, and we could maybe get National Department of Social Development as well as province and perhaps some of our municipalities to come and share with us what their policies are as well. Mr. Arnolds?
Chairperson, my apologies. This hand kept on going up and down, but I just also wanted to add to Mr. Sauls to say that, disaster and disaster management requires a comprehensive response. And so therefore, following the assessment, the different role players would then provide assistance in the instance of the Department of Social Development, particularly when there's death and trauma, that the provision of psychosocial support becomes critical to those families, so that in the end it becomes almost a wraparound service. So thank you, Chair.
So, Member Makamapocha, are you happy with us putting that down as something that we'd like to explore? Because I'm certainly very interested in getting more information of how this works.
That's proper, Chairperson. That would be great if the department can, or if we can get information from various municipalities and deal with such cases. Thank you.
Thank you. Members, with that, I want to say thank you very much for your time this morning, and a very specific thank you to our colleagues from the legal department, to Advocate LaRue and Advocate van der Schuyf, as well as to our colleagues from the department. Thank you very much for your help in getting us to this point. A very special thank you to our very capable and competent procedural officer for all your work, as well as to Mr. Daza, and then to our technical team for making sure that we're able to have this meeting. Our next meeting is on the 13th of October. And we will then also, you would have received the updated proposed meeting calendar going forward. I'm just going to ask that members also have a look at that and see if there's sort of anything that you'd like to add or anything that you think we should place a special focus on, etc. Are there any closing comments from any members? We're all satisfied?
Thank you, Chairperson.
Yes, Chair.
Nomonde, are you satisfied?
Yes, Chair, but just to let members know that the negotiating mandate is at the NSOP is tomorrow morning from 10 o'clock until 1 o'clock. If members are interested to attend and just observe, I will forward the link to the members. They are more than welcome to just attend the meeting and listen to the National Department and the NSOP members when they engage to the negotiating mandate of the Western Cape and other provinces.
Thank you very much. Please do send that through, Nomonde. I will definitely be interested.
Thank you, Chairperson.
Members, with that, thank you very much. The meeting is then adjourned. I'll see you all in the budget workshop.
Thank you, Chair. Goodbye, everyone.
Thank you, Chairperson.